Good morning, everyone. You're very welcome to this morning's webinar. We will just give it a couple more seconds just to allow other people to join, and then we'll commence shortly. Okay, good morning, and thank you for joining our Workplace Risks webinar this morning. We are going to be discussing the changing scene in risk, compliance, safety, and environmental management in the industry. We are particularly going to be focusing on what has happened over 2025, a look back on this year as a whole, and then we're really going to focus and delve into what commercial and residential property leaders really need to know going into 2026. But before we go into this morning's webinar, what I would really like to do is discuss who we are in ARC Workplace Risk and a bit about us and our background. So within ARC, we very much see ourselves as a company that empowers you to confidently manage your risk, your safety, and your compliance. And we build that through partnership and provide you with the tools and innovation that you need to navigate the ever-changing legislative environment. Within ARC, we have over 30 years of industry leadership, and we serve as a direct extension of your team. We deliver tailored solutions that not only just protect your people, but we also protect your properties and your operations for that complete peace of mind in order to navigate the environment. ARC's approach, we very much combine the industry's top consultants, and we have our intuitive CUDA platform, which enables you to simplify your overall compliance management. It saves you time and it allows you to focus on other critical tasks. So beyond the day-to-day support, we in ARC, we guide you through complex, contentious and critical situations with confidence. We provide you with the tools and the insights needed for you to make that well-informed decision in any scenario moving forward. This morning's webinar, it will be delivered by myself, Tara Brady, and my colleague Shaunna Thornton. So I myself am the Principal Management Consultant within ARC Workplace Risk. I have over 12 years industry experience across various different sectors in Ireland and the UK, and I'm within ARC up on 4 years. My colleague Shaunna is the Director of Growth and Customer Success within ARC. She has over 15 years of industry experience across various sectors, and Shaunna forms part of that senior management board within ARC Workplace Risk. So we will be walking you through today's webinar. So what are we going to be discussing? So the agenda today, we are going to be focusing on a comprehensive legislative overview. So the agenda really covers key legislative changes across risk, across compliance, across safety and environmental aspects and set for 2026. So we'll really be focusing and deep diving into the post-Grenfell environment and really diving into the Building Safety Act. We will also be discussing fire safety and evacuation. So in particular, we'll be discussing person-centered fire risk assessment and personal emergency evacuation plans. We're also going to look and delve into safety and security updates. So this includes security regulations like Martin's Law. So we're going to deep dive into that, as well as environmental and sustainability focus. So we're going to address environmental proposals such as EPC and MESS, future home standard and the biodiversity net gain. So we will deep dive into that as well. The overall key takeaways from today's webinar, as well as key focus and dates for 2026. So we will allow questions as the seminar goes through, but we will focus and go into Q&A at the end of today's session. We will also have a QR code, which will give you a deep dive further into key standards and the takeaways from this year and next. So I will now pass you over to Shaunna.
Thank you, Tara, and good morning, everybody. Thank you all very much for joining us on our last webinar of the year as we were kind of listening and talking to each other before the presentation started. We've delivered as close to nearly 20 webinars this year, but we just want to thank you very much as we kind of head towards our kind of end of year. What we would hope to bring as part of the presentation today is taking a little bit about where 2026 is going to be shaping the built environment. I think when we were putting together the presentation for the webinar, we were thinking a lot and reflecting back over the last, in particular, 18 months, and in particular looking at, as Tara mentioned, the Building Safety Act. I think when the Building Safety Act came to our shores, it brought a lot of changes. It brought accountability and principal accountability for developers and owners and brought them to the foreground within the built environment. Typically before that, it was very much reliant upon the managing agent and the responsible person to look at those building safety risks. But what the Building Safety Act brought was obviously changes and bringing those people forward and having to answer the really important questions within the built environment when it comes to their buildings. So what we're going to take a look at today is what 2026 is going to bring us. So over the last 18 months, obviously coming off the back of the Grenfell Inquiry Phase 1, Grenfell Inquiry Phase 2, and obviously the Building Safety Act, there's been a lot of shift from policy development. And what we're getting into now within 2026 is actually the implementation of a lot of those British standards. One in particular, which we'll talk a little bit further about, will be BS 994 for fire strategies in buildings. And the aim with this will be to replace the current standard of PAS 911. So this will be setting out expectations for developing fire strategies and the type of information and requirements that's to be considered. So these are just some of the changes that we have to take a look at. And this will not only have a significant impact on our property managers and our facility asset management teams that we're working with, but also those duty holders and organisations. So we're not just going to be, as Tara mentioned, talking about kind of HRBs and Building Safety Act. We are going to be looking at the information that's going to be affecting our commercial buildings as well. So Building Safety Act and the higher risk occupations. So some of you may already be aware, but for those of you that are not, the Building Safety Regulator is going to be transitioning to a new body at the early as January 2026. And this was laid out within Parliament, and they're currently going through a transition phase at the moment. So what the aim will be is that the Building Safety Regulator will formally separate from the Health and Safety Executive, and they will become a standalone body as early as January 2026 under new legislation. This will mean that the regulator will no longer form part of the HSE, but they will still have to remain accountable to MHCLG, or obviously currently the DLUC that we're talking about at the moment. So they will have to go through that transitional period ending on the 31st of December 2026. And one of the things you're probably thinking about is, why are they separating from the HSE after a very busy 18 months for the regulator? Well, it all comes down, I think, to the changes of personnel that you all will be aware of within the regulator. We have Andy Rowe coming in, Charlie Pugsley, and their aim is to try and strengthen and reform the gateway processes that have been heavily criticised over the last 18 months, whether you've got transitional buildings working through kind of the gateways, whether you've got new builds working through the gateways, or whether you've got remediation of buildings having to go through that gateway 2 process. What we have found is there has been continued delays over the last 12 months in particular that were ever been increasing and not reducing. So the plan is to try and streamline by separating from the HSE and to reduce down the delays that we are finding to achieve all of those Gateway 2 application processes, the remediation applications, and also to be able to achieve your building assessment certificate. So what we have been told is that 40% of all HRBs are expected to receive their back assessments by April of 2026. And for those of you on the call, you will know that obtaining those building assessment certificates is incredibly difficult. One of the things that we're finding is inconsistencies when we're dealing with various teams within the building safety regulator. We might be dealing with teams working within the north of England and actually working within the south of England. And what we are finding is actually those teams are looking for different things, and their implementation is looking for different things as we try and achieve the building assessment certificates. There's a few trends that we're finding when it comes to looking to achieve your building assessment certificate. We're lucky we've achieved as early as 13 building assessment certificates for our clients over the last number of months. And the trends that we're finding to achieve those building assessment certificates are you need to have a structural risk assessment in place. It is irrelevant of the age of the building. So even if you've had a building PC as early as last year, you are still required to have a structural risk assessment in place, and it has to be completed as part of your building assessment application and submitted to the regulator. Frustratingly, as we've kind of worked through the process, we found that the goalposts have changed and their requirements have changed. I even remember as early as January of 2025, we were talking to our clients about having a structural risk assessment in place, and the guidance was still not clear. The criteria had arrived in December time, but actually the BSR coming out to say that a structural risk assessment was required, there was a lot of ambiguity associated with that. As we found our way through the last 12 months, we know now that a structural risk assessment is required. Other things that we can see is starting to become a trend as part of the application is your resident engagement strategy and how your resident engagement strategy is applied within your HRB. So we know you need to have individual resident engagement strategies for each HRB, but what the regulator is looking to see is how that resident engagement strategy is to be applied within that building. So it's not okay just to develop a resident engagement strategy. You actually need to be ensuring that the initial communication methods and how you're communicating and cooperating with your residents is working. Tara will touch on it in a little bit further down the line when we're talking about resident emergency evacuation plans and how that fits into the whole person-centred fire risk assessments. But one tip I will give anybody who is looking at a building assessment certificate at the moment, please do not look at your resident engagement strategy as a static document. All of the documents that are held as part of your golden thread or safety case report is a living document. You may be asked to provide updates to those documents, and you have to be continuing, particularly the PEEPs, to ensure that you're assessing building safety risk. And the reason why we're talking of that is because we are expecting a consultation during 2026 to expand the definition of your HRBs. So if we think back to the Grenfell Phase 2, the definition of a higher risk building of over 18 metres or 7 floors or above was heavily criticised. They found that actually you may have very complex, contentious buildings with problems with the external walls, and they may be under 18 metres. So what we are expecting over the next 12 months is that the definition of higher risk buildings will come down between 11 to 18 metres. And it may look at hotels and other complex buildings. So something to be thinking about is have a look at your current assets and the current buildings that you have within your portfolio. Could they currently fall within scope? So are they currently falling within over 18 metres or 7 floors or above? Or if the height was to drop between 11 to 18 metres with 2 or more units, could you then fall into scope under the BSR and a HRB definition? The reason why I'm kind of highlighting to people to take a look at the current stock that you have to see, do you have any buildings that currently fall into an over 18 metre aspect or 7 floors or above, is probably surprisingly or not surprisingly to some on the call, there is still a number of buildings that fall into scope currently that have either not been registered with the HSE or the BSR, which is a criminal offence, or have not started their building assessment process. Now, we're unsure who are maybe the PAPs of these buildings, whether it falls to the likes of developers, owners, or whether it's more to the RTMs or the RMCs. But one thing we will say is the HSE or the BSR are aware, and we know from even people who have been contacting us over the last 12 months to actually say, do I still need to register this building? Is this a legal requirement? So please take a look at the current buildings that fall within your current stock. One of the things I also want to just briefly talk about is also the expansion of what the HSE or the BSR from January of next year are going to be looking for when it comes to your safety case report application. So as we know at the moment, under Section 62 of the Building Safety Act, you have to assess, or the PAP has to assess, fire and structure, but there is a Part C which talks about prescribed matters. What we know is that the HSE currently have done a huge drive with regards to asbestos and strengthening the review and management of asbestos over the last 12 months. What we can see the BSR looking for is actually asking our PAPs to now focus and expand their surveys, clearer duty holders, and better management of older building risks that currently fall into scope for the BSR, and including that within your safety case report. So we can see that happening again over the next 12 months. I think the trends that we're finding, as we said, is with regards to structural risk assessments. We know the resident engagement strategies and the problems we're finding there, but asbestos is going to also be a key element of your safety case report element moving forward. Another thing is condition surveys, so structural condition surveys, very different from a structural risk assessment. But one thing that we are starting to find for buildings that are 3 years and older is that a PPM schedule is just not sufficient anymore. We are finding that the regulator is also looking for not only a structural risk assessment, but they are looking for a structural condition survey that has been completed by a competent person that outlines the PPM over the next 3 to 5 years. So please be aware of that. It is questions that we are starting to see coming through as part of that MIR process or more information request once you're in the process of trying to achieve your building assessment certificate. For the buildings that we have been lucky enough to achieve a building assessment cert, depending on the age, but for those buildings that are 3 years or older, they have had a condition survey and a structural risk assessment in place. So something to bear in mind. So lots of changes coming when it comes to our higher risk buildings in occupation. So the BSR transitioning away from the HSE, an increase hopefully on building assessment certificates being achieved. The requirement still remains for structural risk assessment a part of your application, and that definition of HRBs is to be reviewed, with also the expansion coming into the likes of asbestos being included within your safety case report. The next we'll take a look at is the gateway reforms. And this again comes back to not only the delays and the changes within the gateway regime that I've mentioned on the previous slide that were expected to cover a wide range of refurbishments and alteration activities. And actually to improve that gateway will be incredibly important. But we also have changes coming based off the approved document B. So a second staircase is going to be a requirement for all new residential buildings with 18 metres in England from later in the year, from September of 2026. So where this has come from was introduced following the Grenfell Tower fire and the improvements obviously to the evacuation safety that's required with the one stairwell and the staircase that the LFB were working with at the time. It was confirmed in March 2024, with guidance now incorporated and being implemented from 2026. The thing to be aware of, obviously, as I mentioned, effective from the 30th of September 2026, but we will need to take a look particularly at those transitional arrangement buildings. So these are going to be buildings that are currently working through the gateways and how they will proceed under the old rules, and will they be able to kind of transcribe through before the 30th of September. So one of the things that I will be taking you to take a look at is looking at the viability and the design standards of your current buildings, because we know this is going to be something obviously that's going to be a requirement. The purpose is to provide alternative escape routes and reduce the reliance on a single staircase, particularly when the firefighting service are trying to access these buildings. There is also other changes coming in 2026 with regards to not only approved document B in residential buildings, but also in non-domestic buildings as well. So we know in 2026, it's going to be mandatory in new dwellings, new residential dwellings of over 11 metres to have sprinklers installed. And for our non-domestic premises like schools and colleges, it's going to be mandatory to have those buildings included. Now, one thing I would kind of be saying, if the approved document B is telling us anything, I think it's foreshadowing where the HRB definition is going to start going over the next 5 years. So if we're talking about sprinklers and sprinklers mandatory in non-domestic premises, I think it'll kind of show exactly where things might be going, particularly with those complex non-domestic buildings. As we mentioned, a second staircase will be mandatory in new blocks over 18 metres. Not universal for non-domestic, but you will have to have enhanced escape routes required in those complex buildings. From 2029 onwards, evacuation lists will be required in buildings over 18 metres and required in tall offices and hotels over 18 metres as well. And then one of the big changes is going to be from 2029, it's going to be a standardised illuminated signage in wayfinding signage across not only public and commercial, but also flats. And this is going to be standardised because I think at the moment we are finding that actually it is unstandardised with the quality of wayfinding signage that has been implemented, particularly on existing buildings, but also new buildings being installed. So as of 2029, this will be standardised across. The problems we're going to find, I think, in the fallouts coming from the design standards and the schemes that will shift for these tall buildings is obviously that developers must now kind of accommodate, obviously, these changes that are coming. But the knock-on effect is obviously going to be additional construction costs. And obviously, the aim is to try overall improve the safety and compliance within these buildings. As mentioned on the previous slide, one thing that the HSE or the Building Safety Regulator is now looking to do is obviously improve the anticipated changes of building works captured within the gateway regime. And the aim is to broaden it, clarify it, and make it easier to get your work through the various gateways, whether it is obviously coming from gateway 1 through design to 2 in construction to occupation and gateway 3. The overall impact would be obviously that your structural safety, fire safety, and overall safety case of the building is improved. But as we mentioned and we talked about, there has been heavily criticised the BSR with regards to the current scope being too narrow. It's inconsistent with how it is applied. And also it's incredibly difficult to get these projects through from start to finish. We're actually finding that some of the transitional buildings have been getting through quicker. So the aim will be to improve the defective kind of program at the moment, making it easier for developers and owners to design their projects, but also to achieve that occupation, which is incredibly important at the end. This will be done by siloing the BSR teams. So there will be one team working on the new projects coming through. There will be teams working on transitional buildings. There will be teams working on the refurbishment products, and there will be teams working with regards to that building assessment certificate application. I attended the ARL conference a number of weeks ago, and Tim Galloway was a representative of the BSR at that particular ARL conference. And what he spoke about was actually they found that over the last 18 months, they would have multiple people working on various aspects of the gateway process. So you might have some teams working on gateway 1 in the morning and then transitioning over to looking at building assessment certificates. And what they have found is actually this just hasn't been working, as you will rightly know. So by siloing the teams, they hope that this will improve all of those gateway processes working through. Other items that we have found that we believe they're going to take a look at as part of this gateway regime is going to be that refurbishment piece. So not only looking at individual buildings and actually those commercial elements that might be on the ground floor of a HRB and the work that's required for them to go through that gateway 2 process, which I know has caused huge problems for a number of our clients, but also looking at that definition of minor works. So what's the definition of when you have to remediate your fire doors, or one or two fire doors, or actually a fire alarm system within a building that's critical to life safety, whether it's active or passive, should you have to wait the guts of 15 to 20 weeks? And we have a lot of people that are using the emergency works process to bypass this as well. So they need to take a look at it. They are going to take a look at it, which is incredibly important. So I would expect to see word and an update on that kind of as early as kind of end of January, February time. So the next element, if we kind of talk a little bit about Building Safety Act and obviously the gateway process, the next thing that buildings that are over 18 metres have to be thinking about is the Building Safety Levy. So the Building Safety Levy England regulations is going to be coming into force as of the 1st of October 2026. And the aim of this is for the government to be able to recuperate some of the issues, particularly with regards to cladding and fire. And they're aiming to try and recoup up to 3.5 billion worth when it comes to these type of buildings. So we're still waiting on kind of the operational guidance. So we're still waiting on that firm date, but we do know from October 2026, we believe it's the first, but that might change. Developers who are responsible will be legally required to pay this levy before proceeding through building control. So it must be factored into your development appraisals. And it is related to obviously looking at those safety related costs. So incredibly important. What buildings fall currently into scope? So a new residential building with more than 10 units. So we're talking about our purpose-built block of flats here. We're talking about our BTR. We're talking about our co-living spaces, or we're also talking about new student accommodation buildings with more than 30 bed spaces. So it does apply across the board, and it's something that everybody kind of needs to be thinking about currently at the moment. What new buildings will you have? Are there currently going through the process? Have you built in your development appraisals and your fees associated with actually payment? Because obviously this is going to be required before it can get through building control. Now, one of the things to be aware of is that this should have been implemented as early as March 2024, but with problems and government exemptions and trying to kind of understand how this is going to be implemented, we have had to wait until October of 2026 for this to be implemented. There will be some exemptions, we believe, to obviously the building levy. Probably affordable housing will fall outside of this, but it is going to be an impact from the development, the viability, the modelling for your schemes as late of 2026. To understand kind of how that works and how actually they come about devising what that levy is going to be is still to be decided, but we believe it will depend on the floor space, and it will be measured using the GIA within the square metre set within a local authority. So interestingly, we wanted to show you some of the rates that are expected throughout the country from October 2026, with Kensington and Chelsea being the highest coming in, and then obviously County Durham and more within the Midlands and West Midlands being cheaper. So that's just kind of an interest to show you actually what that is going to look like. We also, and developers will also need to consider if they are going to be subject to residential property development tax, which will be a 4% tax on profits exceeding 25 million. BTR developments are typically exempt from this, but it is something again that we are recommending that you take a look at over the next 12 months. Time to get ready. So next up is construction products reform, and this is obviously coming post Grenfell. So again, all of you will have known about the Grenfell inquiry and the products associated with the type of products and the testing reforms and the fraudulent testing certificates that were seen and implemented around Grenfell at the time, Kingspan, K15, to name but just one. So what the construction products reform is looking to do is to set a standard within the industry, recommending that there is future regulatory framework with a strong policy and scrutiny on the types of construction projects and products used within the industry. The aim will be to create a greater testing, declaration, and traceability. So one of the BS standards that will start and begin the process is going to be the BS 8670, which is Competence Frameworks for Building Safety. And what we're going to be taking a look at, and very much links into the competency, which is kind of the word 2025, is looking at those core competency criteria, around 15, that's required in which to work within the built environment. From there, it will place a greater due diligence, not only on the owners and the developers, but it will also place a greater due diligence on those responsible persons, managing agents, asset management teams, and facility teams, to ensure that the companies and the people that you are working with have the correct insurance, they have the correct skills, knowledge, and experience in which to complete this work. So very, very important. So that's going to be looking as early as expected from 2026. What they also will be looking at with regards to kind of that testing and traceability is not only looking at kind of where the products are coming from a manufacturer and supplier side of things, but actually looking at those testing methods, because we know they have been heavily criticised. One of the things from a construction element that the HSE in the UK, based on certain types of products that are being used, but actually the way in which construction is being managed. And if we think about the reform of the products and obviously the gateway process, is they believe that there is over 1.3 million that is a cost to the construction industry based on accidents and ill health attributed to not only the way in which construction is carried out, but also to some of the products and the way in which these buildings are taking place. So they wish to look at not only competency, but also take a look at the traceability of how this is going to work within the industry. So something to bear in mind. One of the other things we want to obviously take a look at, and I have a slide on the next when it comes to Grenfell phase 2, and we're talking again about competencies. So what we have found over the last kind of 12 months is that we need to be looking at not only kind of our competency frameworks, but also the competencies when it comes to fire engineers and also fire risk assessors. I think everybody on the call will know how heavily criticised the IFE was over the last 12 months, particularly with regards to the scandal surrounding the external wall issues. And what this has done is shown that that what we need to do is tighten the competencies and registration schemes and actually have a framework that every company needs to be working from. It does, as I previously mentioned, place the emphasis back to you. So you have to be looking at verifying those contractors. It's incredibly important. And if we take an example of that, one of the things that we're going to be taking a look at, even if we follow it through from kind of that gateway 1 process right through to occupation and to existing buildings, is if we think about products currently at the moment, we have a new BS EN 1634, which is fire resistance of doors, that's going to be coming in as of the 30th of September 2026. And this will apply again under the approved document B for buildings that are over 18 metres. And this is going to be a standard that's going to primarily recognise fire door testing. So this is something that we have seen become hugely popular within the built environment, particularly where there is concern with regards to the integrity and the fire resistance of a door. We've seen that actually companies and owners and developers are actually utilising this BS 1634 because the current standard is going to be withdrawn. And what they will be doing and what they are doing is actually testing the integrity of these fire doors to see, can they last the 30 and the 60 minutes. So very interesting to see that's where things are going to be going when it comes to the product reform. There is also going to be a new digitalised standard to improve the golden thread information. And this is going to be utilising health and safety information, but building it into a BIM system. And the importance of this will be at the very beginning, at that design phase, that it will be captured through to occupation and that regulation 38. So we know that was improved over document B over the last 12 months, but they are looking at improving that even more using the BIM standard. So again, a really positive approach for the construction industry. Last few slides then before I pass over to Tara is talking about competency. And I mentioned at the beginning, I think 2025 as a whole, the word of I think the entire year has been competency, understanding if you are competent to work within the industry, if you are competent to be able to support developers, owners, and managing agents within the built environment. And this just doesn't apply to the residential sector. This applies across the board to the built environment. So this applies to every building that falls within scope of the built environment. So our commercial, our complex buildings, our hotels, our colleges, our schools. Competency is key across the board. So as we mentioned, obviously we've got our competency framework in place, and the Building Safety Act has kind of brought this along. But the next stage, as we know, is BS 9792. So your fire risk assessment housing code, and obviously 8674 is the competencies of fire risk assessors. These are replacing not only PAS 79, but also they are now defining competency levels as part of actually working within the built environment. Now at ARC, we've been calling for a competency register and competencies of fire risk assessors for a very, very long time, because we know, and if Grenfell taught us anything, that there is not always the same competencies held within the industry. So it is incredibly important, particularly if we look at BS 8674 and competencies of fire risk assessors, that the companies that you're working with can demonstrate the competency levels of assessors that they have within their company. And we do so at ARC. We have looked at all of our competency levels, and what the competency BS 8674 outlines, whether they are at a foundation, an intermediate, or an advanced level. And this very much can link to external accreditations as well, like the IFSM, which we have been working with. And this will shape how fire risk assessments are going to be procured, but also evidenced. And this is really important because if you currently have a building that falls into scope with the BSR over 18 metres, 7 floors or above, we can see that trend taking place. We can see the BSR asking for the competent person and the PAP to prove that they have the skills, the knowledge and the experience to complete the work, to write the safety case reports, to recommend remediation within the building, to confirm the strategy within that building. So again, really important. But as we mentioned, this applies across the board. We know that there is commercial buildings, hotels, we know that there is care homes that are equally as complex. So as we mentioned, this now new standard will redefine how you procure and how you have evidenced how you have procured that third party. So just very briefly, just to mention Wales and Scotland. So Wales will now have the new regime coming in place, where they have mentioned that there is now going to be annual fire risk assessments. You will be registering your HRBs with the local authority, and they will monitor and maintain the HRB regime. So it's not going to mirror the BSR's system exactly. However, it will be that you will have 11 metres or above with 2 or more. You will have to apply and register your buildings. So really interesting that there has been a deviation, because the local authority will manage the registration and the the BSA regime within that. Where it gets complicated is obviously Scotland are now currently going through their cladding remediation guidance and their competency reforms. They have publicly accepted the Grenfell findings and the recommendations. So we're just waiting for them to strengthen their ongoing kind of evacuation guidance and influence on their operational preparedness and design. One place where it will become challenging is if you have cross-border portfolios. So what you will need to do is look at buildings that are spread across England, Wales, Scotland, because a single UK compliance model no longer is workable. So each place has their own regulatory frameworks, their own obligations, their own strategies, their own fire risk assessment cycles, their own competency expectations and requirements, and different enforcement cultures. So what we have been supporting our clients with those cross-border portfolios is actually mapping those out, looking to see where those buildings are located and looking to see what currently applies, but more importantly, what's going to apply in the next 12 to 18 months. So at the moment, I'm going to pause and hand you over to Tara.
Thank you, Shauna. So what I really want to deep dive into, as we said earlier in the webinar, is legislation that is coming into force and how it's going to affect us going forward in our properties. So in particular, one of the key pieces of legislation that has come to force now is the Fire Safety Residential Evacuation Plans England Regulations 2025. So these regulations were laid in July this year, and they will come into force in April, so the 6th of April next year. So previously, ARC, we have gone through a number of different webinars, deep diving in particular into this topic, and we've had a lot of our clients come to us to look for that support and navigate this new piece of legislation and how we can support and ensure that they're set up for success. But this particular piece of legislation is implementing one of the key Grenfell Phase 2 recommendations on evacuation, in particular looking solely at disabled and vulnerable residents. So by requiring now that a person-centred fire risk assessment, so here I'm referred to as PCFRAs, and you'll hear that word a lot in the coming months, is in particular for residents in specified buildings who may have difficulty evacuating should an emergency event take place. So it's mandating now that we have residential personal emergency evacuation plans for those rents that fall into that category. So it requires building level emergency evacuation plans and appropriate information sharing with the fire and rescue authority, so our local authority. So, for example, premises information boxes that we have at the front of our premises, and in order to have that information to hand. So the difference here is this does apply to all of our buildings that are traditionally classified as in scope for the Building Safety Act, but we also now have buildings that are 11 metres and up that have a simultaneous evacuation strategy. So it makes sense, and there's a logic to why these buildings have also been called into force, because we need to ensure that any vulnerable resident or any resident that requires additional support is able to evacuate safely should it be needed. So what implications will this have for property managers and management and our responsible persons for our buildings that fall into this category? So property teams must introduce very clear and very concise processes to ensure that those residents can be identified. So we are aware of who our residents are that will require this person-centered fire risk assessment, rather than purely just relying on self-disclosure, purely just relying on our residents to us and communicating to us. We need to introduce a process to ensure that we have an ability to identify who these residents might be. So PCFRAs and the ongoing requirement for our personal emergency evacuation plan maintenance will place a significant demand on staff. So many organisations are looking to rely on external consultants until that internal competence and that internal capability and resources up. So this is why we've had such an influx of different organisations across England coming to ARC for that support. So systems must be able to hold resident information securely, and we need to be able to share that relevant detail with our local authority, with our fire and rescue services. So strong data governance and ensuring that we are applying our GDPR compliance will really be essential here, because we are dealing with resident sensitive information. So new evacuation plans that we have to implement may require enhanced signage, for example, in our properties. We may need to look at furthering alarm strategies in our buildings, or we may need to look at equipment in our buildings, such as evacuation chairs. Capital planning may need to begin very, very early. As we know, from April 6th, this will come into force. So there are other aspects that we need to think of here to ensure that we are setting up these residents for success with being able to evacuate our buildings. So December 2024, if we take a look back, the emergency evacuation information statements and that overall response outlines what the government saw as a practical and proportionate response to the Grenfell recommendations. And this has included the residential PEEPs. So we expect as this comes into force that there will be additional case studies. We will have more tangible sector examples in this category and clarifications and more clarity as the regime begins to bed in. So this is what we're expecting now in England at the moment, as it only has come into force in England at the moment. But if we were to look at the likes of Wales or Scotland, we know that they are already enhancing their own programs on evacuation and looking at our disabled residents for support. So cross-border portfolios will also need to be monitored and look at the different requirements. So as Shaunna spoke on earlier, the cross-border portfolios are really something that needs to be reviewed in detail, and understanding of the requirements where we have bordering portfolios across Wales, Scotland and England. Another element I'd like to discuss in terms of legislation that we're looking to talk about is security and terrorism. So that's now commonly referred to as Martin's Law. So this is the Terrorism and Protection of Premises Act 2005. So this particular piece of legislation, so Martin's Law, as it's commonly referred to now, received royal assent on the 3rd of April this year. And it currently applies across the UK. So it's looking at England, Wales, Scotland, and Northern Ireland. So the Home Office has stated that the government intends on an implementation period here for this particular piece of legislation of approximately 24 months. So the implementation period will be looking at a trajectory of 24 months before this act truly comes into force. So this purpose and the reason that it's being adapted in this measure is to ensure that we can allow the Security Industry Authority, so the SIA, to establish the new regulatory function and for the duty holders to be proportionately and appropriately prepared for the implementation of this key piece of legislation. So this will then imply, and what this means in essence is that no earlier than April 2027 for these full legal duties to be implemented. But if we look at this year in 2025, and in particular leading into next year in 2026, these are really our key preparation years. These are where we need to come into focus, look at our current properties, look at how Martin's Law will affect us and how we can get ourselves set up and ready for this implementation period. So the Act itself, so Martin's Law, it applies to a very wide range of publicly accessible premises. So if we look at examples, this would include the likes of some parts of our larger mixed use residential buildings. It also will apply to our retail buildings, our leisure buildings, education, healthcare, and our transport assets. So there is a huge amount of premises across the UK that need to be set up for success to ensure that we are ready based on the requirements of Martin Law. So when we look at what are requirements, there is defined occupancy thresholds that based on the level of occupancy that these buildings can take, it's a tiered process. So we're looking at 200 plus members of the public, and there are tiers as well of 800 plus as well. So buildings that have the occupancy and the ability to take in this level of persons to our premises. The law and the Martin's Law requires that a standard duty, so this is a standard duty premises where we have the ability for 200 to 799 persons to mainly to notify the SIA and implement those proportionate public protection measures. So our evacuation measures, our in evacuation, our lockdown measures, our communication measures. So that would be what would be categorized in the legislation as our standard duty premises, so 200 to 799 person capacity. We also then have a higher level, so this goes into what's referred to as the enhanced duty premises and event capacity. So this is where we look at 800 plus persons. So in these enhanced duty premises, we need to ensure that we carry out structured risk assessments. So on carrying out these structured risk assessments, we need to ensure that we're implementing physical and organizational protective measures here. So this is to ensure that we keep our documentation and designate our senior responsible individuals in our buildings. So there's a higher level of requirement here when we look at those premises that can take that enhanced capacity of members of the public and persons in our buildings. When we look at Martin's Law, then in terms of 2026 and looking into next year and what we look to expect from 2026 onwards, we really need to know where we stand, how and when we start to prepare. So the establishment of the SIA's new Martin's Law regulatory function and statutory guidance on compliance will be sector-specific guidance. So the government note already issued for educational settings, for example, but this is going to be expanded to other sectors, including the likes of retail, our leisure, our housing and healthcare, as I mentioned earlier. When we look at premises, for example, that are mixed use or campus style assets where parts of the estate will fall into Martin's Law and parts of the estate will not. So for 2026, what do we need to be looking at here for these type of mixed use or campus style premises? We need to be able to create a map here of where our premises are, where our map is, where events are likely to meet the 200 threshold plus or the 800 threshold plus. So we need to undertake the development of our security risk assessments, undertake our training, conduct our emergency preparedness tests, conduct our auditing, ensure that we're aligning our security risk assets and assessments with the fire and building safety cases where this is appropriate, and ensuring that we're continuously updating our contacts. So ensuring that we have the correct service contacts for our security, for our facilities management, for our event staff, our event management, to ensure that the duties are appropriately allocated and aligned. And we are updating this all the time to ensure that we have the accurate, the up-to-date and correct information here. So there are a number of different level of requirements, but 2026 is really our key year for emergency preparedness when we look to Martin's Law. Stemming on from Martin's Law, another key area I want to look at is next year. So the Health and Safety Executive, so the HSE, where are we looking to in 2026? What are the key priorities that the HSE is looking at when we go into next year? So the Health and Safety Executive has created a 10-year strategy and the 2025 to 2026 business plan. This has signaled a broader mission. So the HSE is no longer focused solely on traditional workplace safety. So we now see that the mission has extended out further from what we would traditionally have classified as your traditional workplace. So the HSE's mission now really extends into public assurance, and we're covering environmental risks, we're covering building safety risks, and its support role really to the building safety regulator. So this marks a particularly interesting shift and a mark toward a more integrated whole system approach to safety across our workplaces as well as our buildings and our public safeties. So what we in ARC have seen that the HSE is giving as priority themes to include the likes of work-related stress, mental health, musculoskeletal disorders, construction safety, and overall support to the building safety regulator. So these priorities reflect where the HSE sees the greater impact on health and safety and health outcomes and risk. So, stress and mental health will continue, as always, to be a major contributor to lost working time in our workplaces across the UK, especially when we look to the likes of musculoskeletal disorders as well. They still remain one of the highest causes of workplace injury in our industries across. So we have to really focus on that as well when we look to navigate of the type of working environments that we now have as a result of post-COVID and the navigation of that. Construction safety, that still remains as a long-standing enforcement focus, and there will be no change to that. The HSE is investing heavily in its role in supporting the building safety regulator when we look at the construction safety element. So what this means, in essence, as we move forward into 2026, we'll have more structured expectations around home and hybrid working as this has become the new norm. So organisations should expect a clear expectation from the HSE when we look to the likes of display screen equipment, ergonomics, and our stress management, particularly hybrid working. As I said, this is the new norm in our workplaces. Employers will need to have that formalized assessment and control, and it's not just policies and statements. So we need to continue that enforcement around managing our buildings. We also need to call in the likes of our falls from height, our asbestos and Legionella, our maintenance and management activities. You know, falls from height is still one of the leading causes in the UK of workplace facilities. Asbestos management, particularly in our building safety navigation, and particularly our older and our occupied buildings, and the maintenance activities that we have to do in our buildings where uncontrolled risks may frequently appear. So proper facilities management and proper management of our buildings will ensure that we can continue to holistically review and adapt our workplace and our aspects of it. So that is really what we are seeing in ARC as the key priorities from the HSE for 2026. I will now pass you back over to Shaunna just to quickly wrap up on our environmental and sustainability targets.
Thank you, Tara, and thank you everybody for sticking with us for nearly the hour. I'm conscious of time, so I won't spend kind of in great detail kind of going into these, but it's important still ever the same to talk about two of the key factors, which is ESG and obviously the changes coming through from the government around the MEES policy and the pathways, and also talking about waste packaging and environmental protection. For those of you as well, we will always share the slides, and we have a QR code at the end that will cover all of the BS standards that we have spoken about over the last hour. So a lot of you will already be aware, but important, as we said, that the government are planning through over the next kind of 2 years to do a reset when it comes to the minimum energy efficiency standards and the pathways and the policies subject to legislation. The working assumption will be that the industry will move towards a minimum EPC standard by April 2027 and an EPC-B standard by April 2030. That is not easy to say after nearly speaking for the guts of an hour. The dates are not locked in. They may shift again, but again, the direction of travel is that most private rented sector stock will need to achieve at least an EPC-C this decade, so that's important to look at. Exemptions will face much tougher scrutiny, and a redesigned EPC framework is due in 2026, intended to support and underpin those potential deadlines. This will come into effect effective of December 2026 with a 12-month transitional period. So again, really important. It's also applying to not only residential, but obviously it will be primarily to your non-domestic commercial properties, with stricter standards emerging actually for those domestic homes, with the aim of increasing and improving energy efficiency and forcing landlords to actually undertake this. So again, really, really important improvements coming. Scotland's Heat in Buildings programme is also launching in October 2026 with the draft energy performance of Building Scotland Regulations 2025. Again, redesigning EPC with clearer metrics, a 5-year validity period, again coming into force around October 2026 with more improvements facing in from 2028 with regards to private renter homes. So if anything has told us over the last 12 months, it's time now to look at those cross-border properties, and it's time to look at the kind of stock and buildings that you have within your asset management piece, and actually buildings that you may own, because there is lots of changes that are already existing, but actually we're having to do a lot of foreshadowing with a lot of legislation and regulations coming into effect in kind of Q4 of 2026. So again, the get ready to get ready phase has begun. And in the last minute that we have, and I'm happy to stay on to kind of cover this off with you, we obviously have the waste packaging and environmental protection, which is the packaging extender producer responsibility. And this is going to make it mandatory to have recycle or do not recycle labels implemented. And this is going to be from April 1st, 2026 for most packaging, excluding flexible films, I believe. And this will be a recognised logo. There will be a guide for consumers aiding to make it clear through specific implementation of details, but it will be mandatory. So that's really, really important, particularly for those of you that may already be working with unified systems. You might already be working with waste companies. You may need to go into a renegotiation to ensure that actually they are adopting this new mandatory labelling system from April 2026. So really, really important. It's binary instructions, and the brand owners and the importance porters placing packaging on the UK market are obligated to comply. Now, there is some exemptions for some of the larger businesses, but again, this is something that we will need to take a look at. But one of the things to look at is check your waste contracts as we move into 2026. So to wrap up, and as we mentioned, the QR code is available. Please do download it. 2026 is the year when scaffolding around all new regimes harden into day-to-day duties. And I think that's a really kind of clear way to position the year ahead of us. We've talked a lot about crystallizing and formalizing a lot of these things we've been talking about over the last 18 months. So we know, obviously, the new building safety regulator is our first implementation from 27th of January. As Tara mentioned, April will bring us the person-centred fire risk assessments and residential PEEPs. September, October and late 2026, we're going to be talking about second staircases, building safety levies and future to safer homes. So I want to thank you all very much for joining us over the last 12 months. Thank you very much for joining us on today's webinar. I know it's not easy as we head into the Christmas break. The QR code can download all of the information that we have spoken about today. Apologies we didn't get to any questions, but we will make a download of those questions and ensure that we provide you with a copy. So a happy Christmas and a new year to everybody, to our clients that are on the call, and to a few familiar names that we see, and we'll speak to you in the new year. Thank you very much. Bye-bye.
Thank you, everyone.